Yes.
It is no sad year way no more contend with judgment way. I buy na a year judgment of trial ye one issue. It na ya steady or say part of.
The entire amateur part of no. Let's clarify to people say we say we call appeal quarter. Ye dey as maybe we can say part we mean to part we mean to. So the president say because of your part na we mean to.
I know more natural part no. Na mean to.
Enti on say now the fourth point now what they are showing actually say they have something that they are holding on to. So if the court in his wisdom question the judgment of court because say on question ya
then additional yes it's at the beginning now can true
per lawyers are ye ni omadi nkomo ne emra kakra yakin kan afa court on sensem ho no say ma ruling wo high court o court of appeal e what judgment ne was so na ye kwa gina so
yes
eno nti ana omu no hunu say si egina sa de na so de now they cannot tender in the fourth element no
until say ya tu egu
per lawyers ye ni omadi nkomo ne emra kakra yakin kan afa court on sensem ho no say ma ruling wo high court o court of appeal e what judgment ne was so na ye kwa gina so
yes
eno nti ana omu no hunu say si egina sa de na so de now they cannot tender in the fourth element no
until say ya tu egu
court no susu say so ni nipa ne ti ye no free mu a ni tiri ma sem bi o de nka ka kire
yeah
ebi o kra o ye wela ne mate to no o ye well
yes
obi ye wela onim obi o so obe ye de asie
yeah
onim abusia no suban nti
o mani pia yo ko makuni ntem makuni ntem
in applying for the letter of administration order 66 rule area of CI 47 it states say every application for the grant of probate or letters of administration shall be supported by an affidavit sworn by the applicant and with such other documents as the court may require. This such other documents that the court may require has neither been stated in the CI 47 nor the Administration of Estate Act 1961 as 63.
63, yeah.
Now, the requirement for any other document is therefore at the sole discretion of the court.
Okay.
But on books one man about the letters of administration and no be captured and say in every application for the grant of probate and letters of administration is by the motion ex parte supported by an affidavit and a set of statutory forms and such other documents that the court may require. One, or say by a motion ex parte. Two, affidavit by applicants identifying the deceased, naming the applicants and their interest in the estate.
Okay.
Place of abode of the deceased, of which date and place of death, whether married and survived by spouses, name of children and their ages. All these things must be captured in there. And so whether married and survived by spouses.
Or me in plural.
Inti obu onoma or wayerenom. It means say you must capture all these people and money in bambi.
Yeah.
Now the C, affidavit of the head of family confirming the facts as contained in the affidavit of the application of the applicant. Inti more and more apply no. Also bunya affidavit of the head of the family. In some context. In some context. Now D, oath of administration not with will annexed. This is a statutory form to be completed by the applicants. To more and more apply for a year letters
of administration
no or say modi adie be declare say nipa no owu ye wa bra wa anye well.
So you need to prove so the will.
Yes. Also prove it. So an oath of administrators not with will and ness. In the next nipa no wa anye well. It must be established. Say wa anye well. And a declaration of movable and immovable properties of the testator or intestate, a statutory form that to be formed and completed by the applicants. Inti nipa no neja padia umuvie ye ni di umuvie nye nyina no wo kan nyina wom now the actually say assume see the entire list be about bonten no
list me say list about it list no way I have a list to suma adofo ni atiefo nhwe bi list I don't know how true this is and I know that it has this propaganda attached to it, and that is the only section I don't want to talk about. For example,
but then this list too is released by a journalist.
Yes. No, but maybe my problem with this list is everyone is estimating building, which is possibly true. And
okay.
But saying bringing name and I don't know is something I don't.
Bringing what?
Would they omudina to as way? Do you understand?
Okay, one thing we know is say fine. You know, say list we know. You ain't mean can say you try and true. But one thing we also know is say definitely your properties are a lumba and Akosua say one year. And your properties and so then ya lumba and then odo Bronii na year. Until I think say be any inform me didn't tell you sir.
Yeah, but
I'm on the na say o man capture.
I'm
on the anymore.
The na 2018 list in the crab go crane away.
Yeah, 2018 or no Akosua say one with the bag.
What did I say? This
Tantra no. Tantra no.
Oh, but make us say, also all stay foreign houses about 3 or 4 people. None of them is captured here. What did I mention?
And Adwato Sibini.
Adwato the
Adwato. Make us say, no, he's saying what he knows. So we can't authenticate.
And that way, no, so Edia Obinade and information.
Yes,
because no need. Lands Commission
and
property but the make us information if you be a baby. Now F nature say death certificate or any evidence of death. Either death certificate or any evidence of death. Na lumba so dey say will be anime. But say anima meka nyina yes some courts require all the above documents.
Okay, so it depends on
to be attached to the application before the application is granted. Some courts.
Top roof timber. Your Kumasi Wood Village. So by na energy seven say ubeto ye nuya ni bia ye nuya de wo Ghana ye nuya na papa. The fact say ye boa no chese inferior na bia na bebrel. Upeto ye nuya baby apeso de kobia de be kwa mawo sa so na pese install boss ma wa eno so ye bedi hu djuma e de amawo fa ye number 0247898528 na contact ye na ye nhwe na ye moa wo na won so no enye baby a wo de ti beto a enkofo ha bia enfamro.
And now some other courts require all the above except the affidavit of the head of the family.
Okay,
confirming the facts as contained in the affidavit of the applicants. And some courts ebe judge na mu say ebusuan panin affidavit ne mbra. Some court also because say oh ebusuan panin affidavit ne kra no enema ewom no eye enough.
Okay, so I at the discretion of the courts.
Yes, so this is enema ewo enema na ye
letters of administration
na ade ba ko a wo hwe said esi ko asubi ewura mu kan nsem ne bebre as to say letters of administration no in Ghana mremu no send a city na hwan etimi kogye ene sa ne mani na wacheche mu bebre PNDC law 111 na kan nsem bebre ho no mo but yo wo hwe mu a priority is given to certain people.
Okay, despite the list, no bobo is oh it's me here. There are priorities.
Yes.
Okay.
Priority is given to the spouses. Spouses.
Okay.
Children. Parents. And now customary successor.
Oh.
The OD. Okay.
Also to me apply.
So they do idea.
Okay.
To the High Court the circuit or the district court by swearing an affidavit detailing the estate and the family.
So these are the priority for all the sibling crowd.
Say sibling bet be do.
Bet be do what? But what be do what there? There can priorities are ain't been fanning come.
Etino spouses. Who say emrane can be or can be say onim Ghana setting a said the city.
Onim yesumai.
Ebi one man na spouse no customary nti omoye more than one.
Okay.
Nti wo kire wo say emrane ma ho kwan. Free say ebi anipa do wuye no wanya well. Say wanya well dia. Na je say omubo obi adin. Enti mu yire nom ne mma no. Na matena se. Aka mo ho abom say
ba kun.
Dabi yedim say ye papa. Owuye no wajapade. Na najapade kra no minim kra no de meme kwa ha. Odo we kwa ha. Wenim we. Enti ye pese ye gitum say se ka wo ho mpo a ya fa sa aka de betua. Obi so the ono so ka so obetua ma because these businesses need to keep running.
Yes.
Enti na almost say immovable and movable.
Yes.
Te bi betumi ya car. Ebu na ye japade esi fa akọ. Enti we must enti sa ni mani ye be capture ni nyina. Na ye de akọkọ to say ye de hye na ofiri mu no. O ye japade we nyina. Ye ne abusua no. Enne ma nyina ni na busua ni we ni. Ya gye atum say ye na ye apply say ye beji na japade ni ahwe so.
As simple as that.
Yes.
Until at the right time you be change japade no.
No, that is a will ni ho.
Will ni ho.
Will ho dia.
Or the executor ho.
Executor no ho.
Yes.
Maybe unse Ghana no ye nim say obi wu a ebusuanfo kwa beka cho say age afeda.
Afeda. Inti from now to afeda no. Kwa na hwe japade no so.
And no say businesses are they know say bia omo heads.
So they can
business
keep
managers.
They can keep it running.
So they'll keep track on those kind of things. No much share say and near money koye till say the rightful people I mentioned omono. Obu okra ne de ejapade amade sa. So sir, somebody has to. And no so kra no o say the letters of our administration yeah amana kwese say
something simple be keke. Yes. It's very complex.
And easy sir. And nontina the court no nim die mu no. Almost say ye nyambu asemu monko we ye she dan for adakra person who say it has been agent.
Me say no because say it cannot be true because it takes 21 days. When so the case back order they sit on it. But it takes 21 days to be done with everything. Yandi asem yandi o.
Na so unim say per document mo de 2 TV so kire say
appeal no
ni niam nyina enye no ya no e de call you
appeal nyamande
no o de hwel
date no
I say
so man job nyamande
do time bi ono ma e na court nsensem no the general public na na sometimes different kakra
yeah appeal date ni say there be our top
I say December 1st December
1st December
2025 no on 12 na same fin no
1st December
yes I call ya check
either 1st or 5th there be 1st or 5th who's that say bibisa first on the 1st December no file bibi we
December 2025
and the court tenaso it's court atenaso
at least
enya fe na akọ court na fe na court afra asem na ya tena so enya akwet ti say wo de wasem aba enti na make say emra no enya fe no makọ court no
court dada which is as far as
but December waiting time within the court needs to sit on this such case within 21 days within 21 days you know court na hwehwe eniema bi ni ade then they will sit on it now if you can say you to that way. And the idea be on say file this appeal no the court of appeal let you and as appeal they are very strategic what they share and they are the same yes
very important very important
but your photo sumame me pe appeal no
yes appeal no okay
no na ehwe
wo baby apese kan na
my brother Asubi did justice
okay
reliefs you know
Okay. Relief sought from the court of appeal. That the whole judgment.
Next one.
Yes, we know.
Open grounds of appeal. And I release.
Release na mepe.
And on number 4.
Open the first one you release now we na appeal they relieve ya.
First one appeal.
So go to the first page. We know
first page.
We are part of judgment of the trial court complain of no. And then grants of appeal. And
when grants of release for
or say
Omudi can file in the first crowd.
When I make
we are okay.
Or say part of the judgment of the trial
court complained of.
Yes.
Yeah.
And the grounds of appeal near the what they call the whole of the judgment of the High Court Kumasi dated 28th of November 2025. And on this
yeah.
And I didn't part of judgment, you know.
And the grounds of appeal, no.
Yes.
It is no sad year we no more contend with judgment way. I buy and na a year judgment of trial ye one issue. It's in a yesterday or say part of
the entire amateur part of no. Let's clarify to people say who's appeal quarter. Ye dias maybe what you can say part we mean to. Part we mean to. So the president is because of part now we need to.
I know more natural part no. So this is the procedure, but make sure say mean
to. And normal grounds no.
Okay.
Or say grounds in tier omu ni say enye part of trial omu nyintu na mom trial ni na omu nyintu me say part of kama me.
The High Court erred when it held that the marriage certificate exhibit B1 and B2 was not admissible per se.
Then
the court erred when it held that section 161 of the Evidence Act is a condition precedent for putting weight on an admitted document.
Right.
It's a third one.
No, uncle the third one.
Yes. Third one, the court erred when it held that the evidence and it's how
the evidence adduced
by the defendant was more credible than that of the evidence of the plaintiff. And for additional grounds will be filed upon receipt of the record.
So far, only 3 grounds now.
Yes.
And he on say now the 4th point now, my dear Beshe actually say they have something that they are holding on to. So if the court, in his wisdom, acquire the judgment of court because say on kwashe
then additional yes, it's at the beginning now true. Then they true, yeah.
It's now the chain.
Because the evidence act and because the evidence act no more quote no
161
some legal people so they know say a court appeal na say this judgment 79-page judgment where that so a hold it here we can't tender anything in again the better media ban say we will speak to the facts and na yan tuma yesterday say evidence act na mujina so de buy no mo ahunu ye enti e kire say the section 136 and 161 of the evidence act and no mujina say then the exhibit B supposedly the marriage certificate has a signature of one Beckham with a German name dated 12/8/2025. 2 documents look similar with similar information, but there is no explanation as to why each has a different signature and date. The court has not been given any explanation as to why exactly Exhibit B, since what was brought as the original was said to be an extract. What the idea about say original for the extract.
So I say extract.
And he also say holding at the identity court natural say evidence at the buy it's not a need munyedu enough in and if the marriage certificate
if it is the marriage certificate
same cannot be relied on by the court as they were not authenticated or identified and certified contrary to section 136 and 161 of the evidence act.
Say any extract impono or jail to say the real thing crana here on yes.
Okay.
And you know
yes.
It is actually on your appeal.
Yes.
And it is on you went into mudia. Not just say and same be akoso judgment ni muso a. Who say judgment no? Nani ma bi wom. Nanya one idea pen and
I mention a lot of things.
And you be brain and until they are seeking redress. And now this is an appeal. So
Zambia say Brano is you feel anymore. Or no, so person boy with architectural designer in ye been come at the amount. So na open say you see the navy, but one food to be bread downless. Open say treaty mawa Zambia construction and services. Italian gravia to Zambia construction and services. Stamp concrete. Nina Zambia construction and service. Opposite floor. The whole Ghana the Ejuma the in India power for 0543 123829 and 0249 711 659.
Per lawyers are ye new madin common emmara kakra yakin kayafa court on sensem hono say ma ruling wo high court o court of appeal a what judgment ne was na ye kwa kwagina so
yes
eno nti ana no hunu say si agina sa de na so de now they cannot tender in the fourth element
no until say ya two egu
it's gonna make us say and near man ebo ba ni nyina no ebi onu na akoya prepreja ososu jana hwe ade say
so
obenya bibia jina so de bibia
Mr. Boss
eno wo ye wo mo
Mr. Boss wo question bi where if you nyansa na mbebusa question you
so emrani mo ne de I know say ye denara there will be interest party or probably parties who will be interested in the case, you know. And to be on my enye na asem per se, but our interest will say the client is in question.
One seminar is yes. So, you know, whatever happens, and I want to be there and find out how it goes.
And when him say, ye kasa kasa nyina say base so be ye well, and na say wanye well no, ni said ye ebinumu susu say na baba jama mo omo ko defend we and also omo show interest in other Bronii case, you know. It means betimi cry takra wo jembi when it comes to every proper way, you know. There is a copy
at the high court, yes, and they're fact. And you know, you can't say they can't tender in a copy of the will after his death. Jail court be no just added that to it's a proper will. Sam pam para. If Daddy Lumba really left a will, copy at the high court to that. It's an if he's all lawyer or no update.
And it could be that maybe based on that, and our court, you know, that Senai.
Okay.
Because same court now will apply to.
Yes. And so they know that there is a will there.
Oh, nipa na would say what should be there, but say nipa no wanye well. Into you person
maybe they find out so no
then no one cast as an intro. But court in him they are not supposed to feed you with those information.
Oh, no, also compare what and be na her ladyship catcher
say
in the process of
the Evidence Act.
And na they are net here so say court news to say so any panity here no free mo ni tiri ma sem bi o din kan catcher
yeah
ebi o pra o ye wela ne mate to no ye well
yes
obi ye wela onim oh ebi also obeye de asie
yeah
onim abusia no suban nti
o mani pia yo ko mokumentem
court no ye no mo de eye the law any common sense because registrar of KUC otaka assembly or say book sense without common sense is equal to nonsense.
It's a common sense no we
yeah until now question now busa Mr. Bones na no say we a common sense question yes a very very important.